Well, I'm going to open the proceedings, first of all, by welcoming all of you here to ICSID. This is normally one of our little hearing rooms, so it's nice to change pace here and to have this book launch. This is also the first event we've had in person since the pandemic, so that is also a wonderful event to celebrate for us as well. Let me start here by introducing your main speakers today. We have Esmé Shirlow, and Esmé is on screen, as you can see. Esmé is an associate professor at the Australian National University's College of Law, and as you know, she is a specialist in international law and dispute settlement. She is a solicitor of the Australian Capital Territory and co-editor of this very lovely volume. I hope that you've all had a chance to see it, and after the event, if you want to sort of flip through the pages, it's fabulous looking, and the content is really excellent, so I highly recommend that. And I'd also note that Esmé is also part of the team that does case commentary in the ICSID review, so we have the joy of working with her in that capacity as well. Beside me, Kiran, who I'm sure many of you know, and I've had a chance to see that many of you are students of Kiran's now, so that is also lovely. Kiran has more than 15 years of experience in private and public international law and is admitted to practice in New York and the District of Columbia, and works with the George Washington University Law School International and Comparative Law Program, as well as NYU's Global Studies Center. And again, we also have the privilege of working with Kiran in the context of the ICSID review and the book review part of it. So we're really very lucky with that. We are also joined remotely by Elizabeth Sheargold, and I don't see Elizabeth yet on the screen. Has she been able to join us yet? Okay, very good. Elizabeth is doing postdoctoral research work at the University of Wollongong, and she has practiced law in Melbourne, was a legal advisor to Justice Johnson at the Iran-United States Claims Tribunal in The Hague, and has her LLM from Columbia and her PhD from University of Melbourne. So we're very pleased to have her join us as well. Farther down the table, we have Judge Charles Brower, who is, I'm certain, known to many of you, is a member of 20 Essex Chambers, has been a judge ad hoc at the International Court of Justice, has been a judge of the Iran-United States Claims Tribunal, and numerous incredibly well-deserved honors for his role and his leadership in international arbitration. And certainly it's been a privilege for us at ICSID to work with him from time to time. Judge Brower is here at the center doing a case, and it's really wonderful to have had the chance to work with him. So we're delighted he is joining us as well today. And finally, our friend Julien Fouret, who is the International Arbitration and Public International Law Practice Group at Eversheds, and he is a former counsel at the International Court of Arbitration for the ICC. He has written and presented extensively, and I would say in particular a book that I think is absolutely a fabulous addition to the literature is there. He did an incredible book on the ICSID Convention and Regulations, the practical commentary. And if any of you are doing scholarly work or if you are practicing in this area, I would strongly recommend go out and buy a copy of Julien's book. So it is really tremendous. So we are happy to have you here, Julien. Let me then start off, and I think this area probably doesn't need a lot of introduction, but as you know, investor-state dispute settlement and investment law has gone through a number of transitions, in particular in the past 20 years. And we've seen a number of states entering the system. We've seen a few states exiting. We've seen a few states exiting and re-entering the system. And we have seen a lot of reform and a lot of discussion about reform. And as part of that discussion, you see states in particular seeking greater control over the interpretation and application of the treaties. And sometimes they're doing this, for example, with notes of interpretation. Sometimes they do this through non-disputing treaty party submissions. A number of ways that states are trying to be more active players in this, other than being named as a respondent, obviously. We have also seen an examination of the bilateral investment treaty network, We've seen the system going from bilateral more frequently to regional. Some efforts to work at sectoral treaties, but as we've all sort of been watching, I think, in the last week or so, the Energy Charter Treaty is going through some of the ups and downs of reform right now, so we are all watching that. And we have the ACMEA decision and all of the various interpretations of ACMEA. So there is no shortage of dispute, debate, and interesting things happening. We also have seen a lot of interesting work in terms of state succession and territorial integrity, and what does that mean in terms of investor-state dispute settlement. And we probably could expect with the Russia-Ukraine conflict that there may well be investor-state cases or investor-state type issues arising out of that. So that's one space where I think you certainly can watch to see some interesting discussions that implicate international investment law. In the center of all of this is what we've been calling the Treaty of All Treaties, or the Treaty on Treaties, the Vienna Convention on the Law of Treaties. And it is meant to guide states and to guide treaty interpreters with how they approach problems under investment and other kinds of treaties, and to provide some kind of discipline and clarity and predictability as to how an issue will be dealt with. Given how complex investor-state cases are now, including with some of these new areas of law and new problems that didn't used to arise, it's really likely that the Vienna Convention is going to become more and more important, and I think more prevalent in interpretations by tribunals and in the toolbox that they are using to solve investor-state cases. So it's very timely to have today's conference where we're dealing with emerging themes and some of the interaction between the Vienna Convention and investor-state law and investor-state issues. As you can see from the book, there is a unique perspective, and it is comprehensive in how it looks at the overlap between Vienna Convention and investor-state dispute cases. So I'd like to get on to hear a little bit more from those who really know, which is in particular our two editors of this text, and we have the authors of 3 of the individual contributions to the text, and then we will have a roundtable discussion. And I hope very much that all of you who have ideas or comments or questions will not hesitate at all to add those to the discussion that we have today. So, Esmé, if I can start with you, when we look at the appendix, it summarizes the Vienna Convention in over 350 different procedural orders, decisions, and awards. And when you think about that, that is a huge amount of jurisprudence. And I think to see the use of this kind of an anchor treaty with investor state, and to see it that much is quite interesting. We recently, with Esmé as well, did some work on the state articles of the state responsibility articles, and it was also very interesting to see there that investor state is taking a lot of inspiration and guidance from those kind of anchor documents. So I'm wondering, Esmé, what do you think practice reveals about the importance of the Vienna Convention in investor state, and about how it is being looked to by tribunals in individual cases?
Great. Well, thank you, Meg, both for your introduction and from all of us to you and ICSID for hosting this event and moderating the panel. It's a real pleasure to be able to join in the discussions, even if only online, and really nice to see such a great turnout in person and online to hear some thoughts and reflections on the book. To answer your question, my goal in compiling this appendix was really to complement the chapters in the book by providing a bit of a snapshot as to how the VCLT has been invoked by parties in investment disputes and how it's been applied by investment tribunals. And one of the key conclusions I drew from compiling this appendix is that there's really a significant body of practice within investment disputes in which tribunals are interpreting and applying the provisions of the VCLT. So as you mentioned, the appendix summarizes applications of the VCLT by investment tribunals in over 300 150 different proceedings. Often they're applying more than one provision of the VCLT in their analysis. So there's really a considerable number of references to the VCLT in these sorts of disputes. And the appendix aims to highlight that tribunals have really had regular recourse to several key provisions of the VCLT, including, unsurprisingly, Articles 31 through 33 on interpretation, but really looking at the breadth of references to the VCLT in investment disputes. As I say in the cover note to the appendix, it's really a key body of practice relevant to understanding how international courts and tribunals are interpreting and applying the VCLT's rules on treaty law in practice, and really highlights the relevance of what's happening in this field to the practice of public international law more broadly. I think the appendix also shows that the VCLT's had an enduring significance in investor-state arbitration, even beyond its application to those issues to which it applies as a matter of treaty law. And the primary way in which the VCLT attains that broader significance is through the recognition by tribunals that many of its provisions reflect customary international law. So tribunals, for example, have applied the VCLT as reflective of custom when examining instruments that entered into force prior to the VCLT, including, importantly, the ICSID Convention. They've also applied it by analogy to non-treaty instruments, including domestic legislation setting up foreign investment protection regimes. And they've also applied its provisions to analyse treaties between parties that are not themselves party to the VCLT. So really, the appendix indicates this emerging consensus amongst investment tribunals and also many disputing parties that several of the VCLT's provisions can be said relatively uncontentiously to reflect rules of customary international law. I think the appendix also highlights certain provisions of the VCLT that haven't had a particular impact as yet on investment disputes, and particularly for me, what stood out was rules on concluding treaties and rules on provisional application from the VCLT haven't had a particular influence in this field of law. And generally, I think that's because those are issues that aren't litigated by parties to investment disputes, or because treaties provide more detailed or different rules on those topics which displace those of the VCLT. But it was also clear to me that some of the rules that haven't played a major role to date may well feature more prominently in the future, particularly, as you've said, as reform and other complexities come to interact with concrete disputes. And so I think, for example, rules around the territorial application of treaties, which is embodied in Article 29 of the VCLT, and also the VCLT's provisions on termination and amendment of treaties may increasingly come to influence this field of law. I think the appendix also shows, in part due to the nature of investment arbitration, that arbitral practice in relation to the VCLT is by no means consistent and coherent. And one of the inconsistencies really laid bare by the appendix are the difficulties that have emerged for investment tribunals applying Articles 31 through 33 of the VCLT. These provisions are really heavily engaged in investor-state disputes, and they're universally almost agreed, as I've mentioned, to reflect customary international law. But arbitral practice grappling with the application of those provisions has really laid to bear the difficulties that can be encountered when applying them in practice. And different approaches have developed amongst tribunals, for instance, grappling with the role of subsequent practice and subsequent agreements between treaty parties, and the role and use of supplementary materials under Article 32, also around the role of other rules of international law under Article 31. 3C, and around the difficulties involved in reconciling different language versions of treaties under Article 33. So really the hope in the appendix is that we can show how these provisions have been interpreted and applied by investor-state tribunals to date, and then the chapters in the book pick up on these issues to consider how the VCLT might be better engaged to resolve these and other fairly foundational issues of treaty law in investor-state disputes into the future.
Tremendous. Esmé, you mentioned Articles 31 and 32, and Judge Brower has written a tremendous piece on those two articles, and in particular, the different styles of interpretation. And I think you've termed them hierarchical and crucible, which is an interesting sort of labels for them and tells you about how they are being applied. So we wanted to know what you thought were the main features of these two approaches and how they're regulated under the Vienna Convention.
international arbitral practice has made kind of a mess of the Vienna Convention on the Law of Treaties. It was supposed to be the victory of those people led by Judge Fitzmaurice, that you don't look for intentions, take the words as expressing the intentions, look at the words, and interpret the words. The opposition, which allegedly lost at the Vienna Convention, was led by another famous English jurist, and that was Sir Hirsch Lauderpacht, who said, no, we got to look at the intentions. And there were a couple of related schools to that. Well, I'm here to tell you that I have sat in 3 of the 4 cases that have been tried under the Argentina Federal Republic of Germany bilateral investment treaty. I didn't sit on the 4th, which was the first, but all 4 of them came out differently, allegedly applying the Vienna Convention on the Law of Treaties. Now, that's an illustration of how problematic it has been. The hierarchical, which I contend clearly was what is in the treaty, is look at Article 31, and if you derive a plain meaning from that, that's the end. And that's what the International Court of Justice has very well said. Don't go to Article 32. But here you discover that those who lost the game in Vienna actually had their camel's nose somehow under the tent of taking the words as they are. Because when you go to Article 32, it says recourse may be had to supplementary means including in order to confirm the meaning when the interpretation, confirm the meaning resulting from the application of Article 31. Well, if you get a plain meaning of something, why would you need to confirm it? This is where things went haywire, I think, at the convention. Now, what happens, obviously, is some apply hierarchically. You stop if you've got a plain meaning, and you don't go beyond that. However, the crucible approach, which is assisted by the way cases are pled in international arbitration and also international courts, you wind up having the whole bushel of 31, 32 poured into the case, and it's very hard for some arbitrators, judges perhaps, to resist taking that as the crucible. Well, we just sort of stir it around and decide what we come up with. You look at everything, and you're not held to a hierarchical approach. Now, this is why I've looking at VCLT. If you go VCLT, I say it's very clearly lost theory. It hasn't worked out the way that it should, as many places as it should. Or if you go backwards from TLCV, I would just say the lost conclusion at Vienna.
Sounds like it needs some TLC, I would say. Julien, your chapter looks at the very interesting question of state succession, and when there is a state succession, does the treaty that applied to the predecessor state follow on and have an application in the successive state, and how tribunals deal with what is a difficult problem and one that we've seen in a number of areas of the world. I wonder if you can tell us a little bit about how you approach that and how you felt Article 29 of the Vienna Convention helped tribunals to deal with those problems.
Thank you, Meg, and thank you to the co-editors for inviting me and for having us provide this analysis of Article 29. So first, I think, by way of introduction, Article 29 is basically the only provision of the Vienna Convention, or VCLT, providing guidance as to which territories of a given state are governed by a given treaty. And just for those who are not completely familiar with it, I will just read it to you because it's really short. Article 29 says, territorial scope of treaties, unless a different intention appears from the treaty or is otherwise established, and that's important, a treaty is binding upon each territory in respect of its entire territory. So you have very, very, very simple words, but actually that are extremely complicated when you try to interpret them. And it's interesting because Meg talked about succession, but because that article has been used as one of the means to interpret how a treaty should apply in terms of succession, but that article doesn't talk about succession at all. It doesn't talk about the context of how to apply a treaty when you have hostilities between states, which might become a problem, which I will dwell upon a little bit later on. So although territoriality has been generally addressed in investment arbitration, usually in the context of establishing whether ratione loci one treaty could be applicable or not, Article 29 itself hasn't been used that much, well, at least I should say, until very recently. Nonetheless, the case law on Article 29 can be split up in two different categories. First, the cases where basically the applicable treaty expressly indicates to what territories it applies. And then the second one, you need to use Article 29 to understand how the treaty will apply to a given territory. The first bit is easy, so I will start by that. One simple example, it's an ICSID case. It's the Menzies versus Senegal case, UK BIT, UK Senegal BIT. One of the claimants was a BVI entity. The UK never extended any of its BITs to the BVIs. So because it was not excluded, even though the Senegalese UK BIT provided for possibility to extend actually the BIT to other territories, it was never made. So basically, the tribunal indicated that that claimant, who was a BVI company, was not, could not bring a claim, so was excluded, and the tribunal did not have jurisdiction over them. Simple. So that's the only example I will take because that's very simple. Now, let's get to the complicated part. And it's the second type of cases that actually arise really directly and are founded under Article 29. How a BIT applies in specific factual circumstances, and I will get back to that, usually in the context of, as Meg said, state succession, or when you have independent and or contested territories. And interestingly enough, what is almost more important in Article 29 is what is not written into it. Because indeed, it has been recognized by the practice, and as has been said previously, the fact that the convention is a codification instrument of a lot of customary principle, it has been recognized that what is called the moving treaty frontier, so MTF, is implicitly codified in such Article 29. And for those who are not familiar with it, the MTF rule essentially provides that when a territory is undergoing a change of sovereignty, it switches from the treaty regime of the predecessor state into the treaty regime of the successor state. So the MTF rule has basically two aspects, one positive and one negative. You get in and you get out. So Article 29 of VCLT doesn't mention that rule at all, but it implicitly reflects that rules. A treaty's territorial scope changes along with changes affecting the territories of the relevant signatory states. And here, because I've been asked to talk to you a bit about how it's been applied, there's two different type of case law. One which was basically the case law that was always cited, which is the old case law, and then the very recent case law. The old case law is a case which is very much known, which is the Sanam versus Lao Democratic Republic. It's an ancestral PCA case in 2013, where basically you had a claimant, Sanam, who was registered in Macau. And Macau, as you probably know, was not integrated into China until 1999. And it was seeking protection, SANUM, under the 1993 China-Laos BIT. And basically, after 1999, sovereignty over Macau was transferred to China, and the central question to the tribunal was whether Macau was considered Chinese territory for the purpose of extending the protection of the China-Laos BIT to SANUM. Absence of guidance in the BIT, there was nothing addressing this issue. The tribunal therefore focused on Article 29 of the VCLT because the parties fought around it. The tribunal considered that in order for the general part of Article 29 to decide whether or not it should be applied and considered Macau as part of China, it would decide whether it needed whether or not it needed to exclude that part from the application of the treaty, whether or not there was an exception in the treaty. While the tribunal noted that the BIT didn't say anything and didn't reflect anything, so basically it decided not to draw any conclusion as to why the BIT was silent on it, but just said there is nothing that we can use in the BIT to say whether or not we should apply it or whether we shouldn't apply it. One interesting fact, which I think probably the tribunal hasn't given too much thought about it, which I think would have been very interesting, is the fact that actually Macau was entering itself BITs. Not many, it had only two, Netherlands and Portugal, for obvious reasons. But the tribunal just said, well, these treaties are just complement to the treaties that China could basically cover Macau, and would be just a supplemental regime that could apply. I think that's a bit complicated in terms of the legal articulation, but so be it, that's the decision. And then the tribunal, at the third point, considered also that the application of the BIT to Macau would not be incompatible with the object and purpose of the BIT. Nor did the tribunal consider that the BIT's application would have an impact on the condition of its operation. So, having found no reason to exclude the application of the BIT vis-à-vis Macau, the tribunal upheld its jurisdiction. There is many more twists and turns to the case, including before local jurisdiction, but for that, you'll have to read the book, because we talk about it. Now, just rapidly, because I will go back to that probably a little bit later on, recently a number of cases have been extremely useful in terms of understanding how BIT cases can be using Article 29, and it's for all the cases that were brought by Ukrainian investors against the Russian Federation for investment made in Crimea. So it's a wave of cases in 2015, because indeed those Crimean cases extended the discussion on Article 29, highlighting issues regarding the actual meaning of the term territory. Because as you will remember, the VCLT doesn't define what territory. It just says its entire territory. It doesn't say what territory. It doesn't say if you have to have a lawful title on that territory or not, whether or not you needed to accept Crimea's annexation of the by the Russian Federation. So, question being, what tribunal would do? Because the obvious questions here is, Russia did this with use of military force and contested referenda, plus a third issue being that the vast majority of the international community do not recognize that Crimea is part of Russia. Well, in the context of the Crimean arbitration, if that were to be the case, then that would be the end of it. If Crimea was Ukrainian territory, then there would be no case, of course. So it's worth noting that since 2015, when the first Crimean cases started, Russia refused to participate in the arbitration, but it's also worth noting that it was only brought by Ukrainian investors. No foreign investors outside Ukraine brought. And I think, and we can come back to that a bit later on, that might have an impact on the way that it has been dealt with. So, five tribunals that have decided that basically, because Russia had the control over that region, it should be held liable for the acts that were done in these regions, notably by Russian military, and therefore held accountable Russia, or actually accepted the jurisdiction of the tribunal for these regions. And although the VCLT drafters intended to use the territory in Article 21 as a comprehensive term designed to embrace all land, all operating territorial waters and airspace, it's a bit complicated to have any other guidance when you look at the VCLT. So basically, tribunals try to build around that and basically made a difference between, and the debate concentrated between the de facto territory and the de jure territory. But I will stop that, so you will listen when I will talk back in a few minutes.
Good. Thank you very much. Kiran, I'm wondering if you noted when you were writing this book if there are any particular developing trends or best practices in terms of how the Vienna Convention is applied in investor-state arbitration. And I can certainly say that when I sort of switched from focusing on WTO, where you had very extensive and detailed consideration of how the Vienna Convention applies, and then moved to some of the early cases in investor-state where it simply says, the Vienna Convention says, and then moves on to whatever is at issue in the case. There's been some different examples of best practice in how to apply the Vienna Convention. So what has your observation been about best practice, and do we see discernible trends?
Thank you, Meg. I'll put it into 3 buckets and start with the notion that states are truly masters of their own treaties. So although they walk away from the negotiating table and have a signed agreement, there's a lot of interest in ensuring that there's control, predictability, coherence, consistency, a lot of buzzwords that we're hearing a lot in reform discussions over how those treaties are interpreted and then applied. So in those 3 buckets I'd put this into, I'll start where perhaps Julien's left off, which is states are quite clearly starting to develop lex specialists in relation to how treaties are applied or intended to be applied. So there might be territorial limits for where treaties may be applicable in the example that was described. There might be interpretive approaches that are specifically identified as part of the way that the treaty's future will live on, and there might be specific rules identified by the treaty negotiators for the entry and exit from those particular treaties, especially in this environment where we're seeing, as you previewed, Meg, a lot of states are not only negotiating new treaties, they're renegotiating, they're exiting from the prior framework, such as NAFTA, for example, and entering into the next generation, which is USMCA, where there's some very specific rules about the transition period and how the sunset period might apply. So that's one great example of what states are doing. Another may be how states are quite, I think, perhaps analogous to the WTO example that you've described. States are being quite express in their treaty-making practices to ensure that they know that the VCLT will be instructive in how future tribunals and decision makers might look at the treaty. So I'll give you one example, and from the book, so right on page 19, the Hungary and Kyrgyzstan BIT, which was entered into in 2020, provides at Article 9.7, when rendering its decision, the tribunal shall apply this agreement as interpreted in accordance with the VCLT and other rules and principles of international law as applicable between the treaties. That might not sound like groundbreaking decision-making or choices, but in this world of BITs that we've seen historically, where the earliest versions, for example, the Germany-Pakistan BIT, the first one that we have, it's only about 5 or 6 pages. And so we're entering a world where the treaties are much more complicated, nuanced, and instructive for the future users of those treaties. So this is a great example, and it's actually a rare example, surprisingly, of where the VCLT is expressly resorted to in the treaty-making practices and for users to rely upon. And perhaps Judge Brower will say that it's not as predictive as we would hope that it would be, but certainly a signal in the right direction. The last example I might give is that joint interpretive notes are becoming increasingly important. So this is, and again, Meg, you previewed this is a scenario where after the treaty has been concluded, perhaps after it's entered into force, and perhaps once a dispute has arisen, that the non-disputing party, aka the home state in a bilateral treaty environment, will provide submissions or perhaps joint interpretive notes between the home state and the host state, or rather the 2 parties to the treaty, where they will provide instructions for what was intended in the treaty language and how it's meant to be interpreted and then applied. So those are just some best practices and emerging practices for how this might all play out to support next generation issues, including as we enter from and exit from and enter into new treaties, and also how new disputes in the way that Julien's also described are starting to emerge.
Good. Now, I understand Dr. Shirlow is on Zoom with us. Is that right? Very good. Well, so pardon me for going back in order, but I just wasn't sure that she was here with us, so I'm delighted. And wanted to ask you about some of these tools that states are using to ensure greater control about treaty interpretation and treaty application. And I wonder if you could elaborate on what's been available to states in terms of influencing treaty application, treaty interpretation. And maybe as a subnote, certainly there's been a lot of commentary on whether this is an appropriate way to affect treaty interpretation at the end of the day. Is it the role of the state to sign the best treaty they can and then it's for arbitrators to interpret, or are they able to use these tools that some would say are ex post facto tools to try and make sure it goes in a certain direction? And that's certainly, I think Ian is here, and Ian will remember that was a huge issue when Canada, United States, and Mexico first did a note of interpretation under NAFTA. And I think there are still a number of the same kind of questions that will arise when we see further actual interpretations as opposed to just the ability to do so. So, Dr. Shirlow, I wonder what your thoughts are on this.
Thanks very much, Meg, for the question and for the kind introduction earlier. And thanks, Kiran and Esmé, for inviting me to be part of the panel today. So as Kiran just noted, states trying to reassert control and really be the masters of their treaties is something we've seen a lot in the last few years in investor-state arbitration. And under the VCLT rules, there are several avenues for states to do this. The ones I focus on in the chapter of the book are VCLT Article 31, paragraphs 3A and 3B, which cover subsequent agreements between the treaty parties and subsequent practice of the treaty parties. Now, it's important to note that these are not dispositive interpretive findings. Simply having a joint agreement of the parties under the VCLT rules does not mean that that is the interpretation that our tribunal has to follow. And what we've seen in practice is many tribunals maybe perhaps taking note of these agreements or practice existing, but in the end, actually adopting a different interpretation of the agreements. And I think what we're seeing that actually lead to is states looking for more control, and in new treaties, actually going beyond the VCLT rules, for example, to set up processes where they can issue a binding interpretation that a tribunal has to follow. But under those VCLT rules, when it comes to subsequent agreements, what tribunals have generally held that requires is that it's a single joint document issued by all treaty parties. Now, in a bilateral investment treaty, that's relatively straightforward because it's two parties. Where you have a plurilateral treaty, then it can become more complicated as to whether it's valid for certain parties to agree on an interpretive approach that other parties to the treaty may not have been involved with. And tribunals have generally been skeptical of that, although the Green Power and Spain decision was one exception to that. But also, the agreement has to relate specifically to the interpretation of a provision at issue. And this has come up in a number of arbitrations relating to a declaration of 22 of the EU members from January 2019, where those EU members reflected on the meaning of the Esmé judgment of the Court of Justice and said that, intra-EU arbitration wouldn't be valid effectively. I'm absolutely simplifying and paraphrasing what the declaration says there. But when that has then tried to be argued as a subsequent agreement, most investor-state tribunals have said it didn't specifically look at the arbitral clauses of individual agreements, such as Article 26 of the Energy Charter Treaty, and therefore it's not a subsequent agreement on interpretation. Again, Green Power in Spain is an exception there, but most tribunals say that a subsequent agreement has to really focus in on being an interpretation of a specific provision. While parties are increasingly trying to use these sorts of subsequent agreements, it is important to note that even where the tribunals find that one exists, they only have to take account of it. They don't necessarily have to follow it or find that interpretation to be dispositive, as I said. Subsequent practice of the treaty parties can take a much wider range of forms and has taken a much wider range of forms in the cases we've seen to date where it's come up. So generally, subsequent practice is an act of an individual state. It could be something as simple as a non-disputing party submission to an arbitral tribunal. Sometimes tribunals have even characterized submissions in other disputes as a form of subsequent practice. We've seen things like public statements by governments or ministers. We've seen exchanges of diplomatic notes be considered as subsequent practice. and also potentially the drafting of other investment treaties or model investment treaties and clarificatory notes that might be included with those model treaties, all potentially being characterized as forms of subsequent practice regarding interpretation, although each of those can be controversial in different ways. But again, here it's only relevant under the VCLT rules if the subsequent practice can establish an agreement between all the treaty parties. So even if each piece of subsequent practice is the act of an individual state, what the states still need to show to a tribunal is some kind of cohesive general interpretation that's been agreed. And even where that can be established, several tribunals have still said, even if this is what the state parties think, we don't necessarily have to follow it, because under the VCLT rules, it's something to be taken account of. And as Judge Brower mentioned a moment ago in his comments, under the VCLT rules, they're generally characterized as starting with the text itself and the text having a primacy. So we have seen, notably, several tribunals say, even if the parties seem to express through their subsequent practice an agreement on interpretation, we may not follow it. And I guess one of the most notable examples from recent years is the Echo Oro and Colombia decision with respect to the meaning of general exceptions, where both Colombia as the respondent state and Canada as the non-disputing party submitted very clearly that they both felt that if that exception applied, there would be no duty to pay compensation. And the tribunal said both the treaty parties might agree with that, but looking at the language and the ordinary meaning, we take a different approach as argued by the investor. So while the VCLT provides these avenues, they're by no means a sort of surefire way for states to control the interpretation of their agreements.
Very good. Thank you. Judge Bauer, what's your opinion in terms of Articles 31 and 32 again? Would you say tribunals, by and large, have applied it appropriately?
I think I already answered that question.
All right.
The answer is some yes, some no. And I think probably the dissenting opinions or the dissenting parts of concurring and dissenting opinions I've written have been largely devoted to what I regard as misapplication of the Vienna Convention on the Law of Treaties. I do parenthetically have a lot to say about this question of interpretation, but that comes, I assume, later in the discussion. It is simply when you've got some people doing the crucible approach and some people following the hierarchical approach. Well, depending upon what you believe is right, somebody's doing something wrong. I happen to believe from the history of the development of the Vienna Convention that it was intended to be hierarchical. Now it turned out because of the insertion into Article 32 that you can go to supplementary means to confirm what was supposed to be the plain and clear meaning of the contract, that has, how should I say, put the Vienna Convention on the Law of Treaties into the category which we saw often when I was at the State Department. Every treaty or convention is, how should I say, an agreement to disagree. Now you expect that in political treaties, but not in what I would regard as a technical treaty, trying to guide people on how they should proceed. So I think that Judge Fitzmaurice would be very distressed were he around today. His daughter-in-law, of course, is around today, and Malgosia, and I haven't discussed this with her. Maybe I should, because she's obviously a very successful professor of international law at Queen Mary. But it is, I'm sorry, it turned out to be what I've said before, and it shouldn't have happened that way.
Dr. Shirgold, if you were advising states who were entering into new treaties, would you tell them that they should have a provision on joint interpretations? And even further, what kind of a provision would you be counseling them to include if you thought that was best practice in the treaties? You'll be aware, of course, that there were some simple, you may do a note of interpretation, and then there have been further ones that have talked about what will the impact be, for example, in the United States, Mexico, Canada, recent agreement. So what would your counsel be to a state about whether to include that kind of a provision and how it should be worded?
Well, my counsel would be that a state should include such a provision. I personally think that they are best practice. But as you note, Meg, there's a lot of variation in how these provisions have been drafted. And under the VCLT rules, a subsequent agreement isn't necessarily binding simply one source. So I think what's really important is that any treaty provision specifies that those joint interpretations are binding on an arbitral tribunal. I also think it's important that they specify if they're going to have a temporal application. So there's a bit of debate in the arbitral decisions to date about whether or not a subsequent agreement on interpretation should only apply from the point at which that agreement is made, or whether it's actually just clarifying what the treaty always meant, and therefore it isn't really changing anything. And so we see some treaties now that actually say that if there, for example, is a joint committee under the treaty who will issue these interpretations, that committee can and should specify the date upon which that interpretation takes effect. And so I think that's also an important thing to clarify, because sometimes we've had tribunals sort of come in and suggest that these interpretations are a retroactive modification of the treaty. But on that point, what I also think is best practice for states to remember is that these are interpretations and not amendments, and they're for a limited purpose. And this is where I think we've had a lot of the controversy around the issuance of joint interpretations come up to date, is where states claim something is a joint interpretation, but when you look at the substance of it, it might be better characterized as a treaty amendment or modification. They're trying to get that in under the guise of an interpretation. And that it might be possible that something phrased as a subsequent agreement on interpretation could actually affect a treaty modification, depending on the requirements of the treaty itself, if it has any specific rules around how it's amended. In the absence of specific rules in the treaty, under the VCLT, the parties have the right to modify their treaties. And if they have that agreement in writing that they want the treaty to be interpreted or to be read or to be changed in a certain way, it might count as a valid modification. But I think it's really important states bear in mind that an interpretation cannot be used to rewrite a treaty. And we've actually seen an interesting example of this recently. I alluded earlier to this declaration from January 2019 among 22 of the EU parties about the effect of the Esmé judgment and intra-EU arbitrations. What we've seen recently, just a few weeks ago, is the European Commission propose a formal subsequent agreement on the interpretation of Article 26 of the Energy Charter Treaty that would formally say, we don't believe that that can be interpreted in a way that would allow jurisdiction between EU parties. But notably, that decision doesn't just refer to Article 31(3)(a) of the Vienna Convention rules. It also notes that it would count under Article 41, the rule of the Vienna Convention relating to modification of treaties. So it seems there that the European Commission titles the document as a subsequent agreement, but in its text is noting that even if you think this is a modification, not an interpretation, we still think it's valid, because there are blurry lines there. And I think that's something for states to be really cognizant of, is we can't over-rely on interpretations, and that we have to note that as amendments and modifications different, might have different processes that need to be followed.
I think that's a very good point. A very different process to amend a treaty or modify as opposed to interpret. So that's a good point. Julien, you were talking about Article 29, and one of the impressions I think that's a fair one is that these have been very fact-specific findings when tribunals have addressed these problems. Is that your view, or do you think that the sort of overall Vienna Convention type guidance provisions have been able to really have an impact?
No, I think you're right. But at the same time, I'm not sure if it's fact-specific or if it's because the provision is so broad that you need some type of interpretation to go back to what we've said, or at least some type of understanding of what it is. But fact-specific, it's true. I mean, to go back to what I was saying earlier, I mean, because we've seen those numerous Crimean cases arising, they've applied a very, as you said, fact-specific approach as to understanding what Article 29 says to be in respect of its entire territory. What was interesting is that I would think that those tribunals did not per se apply what was contained again in Article 29, but rather an appropriately factual approach to decide how to understand Article 29 in such given circumstances that are exceptional circumstances. And I will give you two examples. First, you have the tribunals in Ukr-NAFTA and Stabil versus Russia. Both of them had the same members of the tribunal, so the decisions are obviously exactly the same. They have upheld the jurisdiction, and as far as the territorial application of the treaty, the tribunals analyzed it in three different points. First, they've applied, they said, the VCLT rules on interpretation in order to find the ordinary meaning of the term territory. And what they said is that it was broad enough to cover the entire territory under Russian control. And I'm saying that with all the caveat because most of those decisions are not published, so it's what you could gather from the comments that you've had. And so basically, the Article 29 was used to indicate that a treaty is presumed to apply to a state's entire territory not being limited to a territory under the state's lawful occupation, which is nowhere to be found anywhere, but it's very, as you said, factual specific, and I would say, at least in this case, necessary for the tribunal to take the decision that it wanted to take. And the tribunal went even further, saying that there was no evidence of a contrary intention in the BIT, and concluded that basically the territorial scope of the BIT would extend to the Crimea Peninsula, therefore Russia should be held liable to whatever has happened in that peninsula. Because of all what has happened, basically the referenda and all the steps that had been taken from the Russian to say, well, it's our territory. And furthermore, the tribunal observes that other Ukrainian and Russian BITs tied the definition of territory to sovereignty, which was not the case of the Ukraine-Russian BIT. And plus, the tribunal took also into account declaration by both Russia and Ukraine that Crimea was part of the Russian territory. And it's interesting because Ukraine intervened in most of those cases as amicus curiae, saying that, and I quote, Crimea remained Ukrainian territory, but that Russia's current occupation meant for the purpose of the BAT that Crimea was presently, quote unquote, part of Russian territory. So this, it cannot be more fact specific than that, at least in that context. Because of what the tribunal wanted to achieve, it had to interpret it that way. The problem being that these findings have sparked a lot of criticisms, mostly from public international law scholars, who have noted that the tribunals lack jurisdiction on the basis inter alia that under international law, Crimea was still Ukrainian territory. Indeed, annexations by force are illegal and not recognized under international law, making the application in principle of the MTF rule under this context very questionable. Hence, the tribunal have placed more emphasis on the, I would say, de facto situation on the ground without actually examining the question of the legality of the annexation. The reason being, of course, that it's not necessarily within the jurisdiction of those tribunals to decide whether or not the annexation was lawful or not. And what's interesting is it doesn't change when it goes before local courts, and that's where I will finish, because one of those, or at least the two I've mentioned before, the Ukr-NAFTA and the Stabil cases, went before the Swiss courts, because Russia actually asked for the annulment of the jurisdictional awards. It didn't participate in the arbitration process, but asked for the annulment. Its only argument was that the BIT only encompassed the territory as understood when the BIT was signed. That basically, that in 1988, that was the territory of Russia. Nothing since 1988 has indicated that Russia was accepting that under the BIT, the territory has changed. However, Russia was unable to produce any evidence to support its case. And what is interesting is what the Swiss Federal Tribunal said when it sided actually with the tribunal. It said, and I quote, The deciding point is that according to general principles of international law, in the event of territorial changes, a treaty is still applicable to the new entire territory. And again, I think it's also because it was what they wanted to decide and was in interest of justice in that case, but it's very, very fact-specific to the list.
As a general proposition, it may not be as simple to come to.
Exactly.
Well, we wanted to have the last round of discussion here to be about the role of the Vienna Convention in the future. And maybe, Judge Brouwer, if we could come back to you, and in particular take advantage of the fact that you've been on a number of different tribunals and different adjudicatory bodies, so you've had a chance to see how the Vienna Convention, in particular Articles 31 and 32, have been applied by those bodies. And do you think there's anything perhaps that investor-state dispute tribunals might be able to learn or to follow from different approaches to this taken by other adjudicative bodies?
Well, I believe that the International Court of Justice basically, year in, year out, has done a pretty good job with the Vienna Convention on the law of treaties. And of course, the 15 elected judges, as they are from time to time, and occasional ad hoc judges seem to get it better. Everybody here all right now? Thank you. That's just my observation, and I think it is correct. So international arbitrators come from a lot of different places, some with judicial backgrounds, most of them not. They've been in practice, or they've been in the academy, or they might have been any number of places. And they just don't quite get it right all the time. Will that change? What's the role of the Vienna Convention? It's like I guess everybody's centenarian mother-in-law. It's with us. It's part of life. We will all have to deal with it forever. And together with the ILC's articles on state responsibility, it's one of the two most important, enduring, ever-present, universally to be applied work of the International Law Commission. So I hope it will tend more to be honored as what I think it was intended to be, which is to be applied hierarchically. As I've mentioned, I think earlier, that's made difficult by the fact that neither arbitrations or judicial proceedings give an opportunity. Let's look at Article 31 first, stop there, and see where we wind up. You wind up with the claimant throwing everything into the basket, so they won't be blamed for not bringing it up later in the reply. And so everything is there spread at your feet as an arbitrator or as a judge. And it's very difficult for some people to, working with that procedure, compartmentalize their mind and forget about Article 32 when they're working on Article 31.
Doing it in stages might give you a more clear analysis.
Yep.
Yeah. Well, Dr. Sheargold, I know in your chapter you talked about the triangular nature of investment treaties and their interpretation. And I wanted to see whether you thought that the tribunals have been influenced by some of the more theoretical considerations when they look at the role of an interpretive note. And, for example, other interpretive instruments like a non-disputing treaty party submission. What would your thought be on that?
So to date, Meg, I don't think the tribunals have really explicitly engaged with this notion that investment treaties are triangular. Certainly, they don't sort of talk about it directly in that kind of language. And when I say they're triangular treaties, and I borrow the concept from other authors such as Anthea Roberts, what we mean is that they're treaties created by sovereign states, but that grant enforceable rights to third-party beneficiaries, being the investors. And tribunals don't tend to actually frame it in that way or discuss that when they're looking at Article 31 of the VCLT or potential examples of an interpretive note or non-disputing party submissions. There are a couple of disputes that are an exception to that, where the tribunals actually do come very close to explicitly engaging with this. And those are generally cases involving a jurisdictional issue, and where the question goes to whether or not there actually is a basis for the tribunal to hear the claim itself, and whether or not there's been the interpretation may have actually removed that ability to bring the claim. Because what tribunals tend to look at there is a notion that the investor has an acquired right, and that an acquired right can't be taken away by an interpretation by the state's parties. So one example of that is the Essex and Italy case, which was again looking at this the declaration by 22 EU members about intra-EU adjudication. And there, the tribunal said they had many problems with framing that particular declaration as a form of a subsequent agreement, but they said even if it was, it couldn't take away a claim that was already on foot. It couldn't take away an acquired right of an investor in a case that had started before that declaration was made. Now, other tribunals have taken a different approach. The Green Power and Spain Tribunal, for example, said there isn't an issue of taking away or modifying investor rights, because when we're looking at an interpretation, we're not actually changing the rights under the treaty, we're just clarifying what they always were, what the words of the treaty have always meant. So there isn't that sort of a shift. But generally, tribunals, I think, don't engage explicitly in that analysis. Under the VCLT rules, I don't think the tribunals should necessarily be influenced by the fact that these are triangular treaties in terms of their interpretation. VCLT Article 31 is very clear that these treaties, like any other treaties created by states, that those states can have a role in trying to shape them and influence them through their subsequent agreements and practice. But as I've said, those agreements aren't dispositive under the VCLT itself. Only if there's something in the investment agreement making the interpretation binding does the tribunal actually have to follow it, if they think it, for example, doesn't accord with the ordinary meaning of the treaty terms.
And that would probably distinguish then the interpretive note from the non-disputing treaty submission, which really is at best advocacy as opposed to anything that might be approaching binding. Is that sort of how that would fit under your approach to this?
I would agree with that. I mean, tribunals have taken very different approaches to the non-disputing party submission. Some have said even if all the treaty parties agree on an interpretation, that the tribunal still won't follow it if they think the ordinary meaning is clear in a different direction. Other tribunals have said they have to give it great weight, even if they're argumentative statements. If all the treaty parties are aligned, if you have, say, NAFTA Article 1128 submissions from all parties that agree, some tribunals have said that has to be given great weight as they're the treaty parties. It's a real sort of discrepancy, I think, in the arbitral jurisprudence today.
And we've seen one or two cases, not often, where the non-disputing treaty party submissions actually aren't aligned, which must present an interesting challenge for a tribunal. Julien, if I can come to you and ask the question about future, but from the lens of Article 28, we know there are a number of difficult situations out there politically, and in particular, we see a lot of news about the unfolding situation in the Ukraine. Have you given any thought to what the role of Article 29 might be in that kind of a context?
A little bit. No, but I think that will not come as a surprise, but the Crimean cases will probably be the foundational cases for anything that will happen now, at least regarding these disputes. I mean, but that doesn't come without some limits or some interrogations as to how it will happen. I mean, the first obvious one is the questionable limits of the arbitrator's judiciary powers, and which warrants probably further attention in that context. More interestingly, it's the clash of interest between the protection of the private actors, i.e. the investors in those type of cases, and what the international community's condemnation of Russia's unlawful annexation of Crimea has actually brought to international law, and how arbitral tribunal will deal with that. I mean, the unfortunate events that we're seeing in Ukraine, I think, are most likely to have more cases coming in, notably by Ukrainian investors, which will continue to bring claim against Russia under the Ukraine-Russia BIT. It remains to be seen whether all tribunals will take exactly the same stance, saying that it will not apply the Article 29 of the VCLT as a de jure territory, but rather as a de facto territory. And it's complicated, and I think it will get even more complicated with what's happening right now, because when it's in the event of an illegal annexation of a foreign territory, is the occupying state responsible for the protection of foreign investment in that territory, and for which amount of time, and how long until it's actually either given back or taken definitely? Because in the context of Crimea, investment arbitration, investment tribunals have so far held always Russia liable for Crimea. But what for the regions of Ukraine right now, that some of them have been recently annexed, some of them have only been under Russians' control for a few months, then taken back by Ukraine. What happens in that gap? So we might have both the issue of the territory, but also the issue of the temporary issue. When was the actual effective control of Russia of those regions for which it should be or could be held liable, because it would be at that point in time considered the territory of Russia, and then for the next 6 months it would not be anymore. So I think it's unclear how the tribunal will use the MTF rule in that type of context. But it's clear that tribunal have deliberately avoided the subject as to whether or not the annexation was valid or not, and I think rightfully. But I think to a certain degree, in any event, those tribunals are bound by what the parties are pleading before them. And I'm pretty sure that the claimants will never plead anything about that. And because Russia hasn't intervened, it hasn't been pleaded. And that's the last point I wanted to make. It might not be the case in the future that it will be only Ukrainian investments that bring claims. And if it's not Ukrainian investors, if it's foreign investors that had interest, would Russia then participate because it's not Ukrainian anymore? And then would that engage a debate about Article 29 and how it applies? I would think so, but it still remains to be seen.
Yeah, that's an interesting proposition. Yeah, that's a lot to think about. All right. Well, let us ask, I'd say, a final question for each of the panelists. And basically, the question is, what does the existing arbitral engagement with the Vienna Convention tell us about the Vienna Convention's possible future relevance here? And I know that's a broad, amorphous question, so I would actually be happy if you had any particular concluding comments or thoughts or points you wanted to make that we haven't so far. If the floor is open now, and then we'd also like to hear if anyone in the audience has some thoughts, or as well, Damon, I don't know if we have anyone over Zoom with questions. All right, good. Then the floor will be entirely for the people in this room at this point, which is great. Julien, why don't I start with you in terms of possible future relevance for the field?
I think I've made my point about Article 29,
I think.
which I think, and I've discussed that with Kiran before we started. I think we might not have expected when we drafted that chapter that it would have been so relevant in right now, and thankfully we didn't expect that. But I think it might warrant a second edition to update the chapter when everything will happen. But I think Article 29 will definitely play a role. I'm not sure if it will actually be applied properly, and I'm not sure it is actually right now applied properly if you look at the pure legal standpoint. But I think it will be building up as probably as Article 31 and 32 have been built up rightfully or wrongfully, and I tend to agree with Judge Brower on some of the misconceptions about those articles in many tribunals. And I think 29 might live the same life and might be at the center of more cases and might actually be a discovery for some parties for other cases than the one that we've just cited. So yeah, that would be my final point.
And an interesting point that you bring up that's often underestimated, I think, is how the parties and how their counsel argue this, or in some cases, if they're not there to argue it, the tribunal can really only go from that jumping off point. So it matters.
And I say that completely on my end, because I've commented a lot the ICSID case law, and I think 1 or 2 times I've had arbitrators coming to me and saying, well, if we haven't said that, it's because the parties haven't pleaded it. And I think that's one point that we rarely raise, but it's the issue, of course, of the fact that, yeah, the arbitrators will only go as far as the party goes, so they will not go further than that. And when they do, it's not necessarily a good thing. So it's, yeah, that's a good point, I think.
Yeah, not what the parties expect them to do, exactly. Judge Brower, final thoughts.
I think I've commented on the future of the Vienna
Good.
Convention.
Good.
When we get to interpretations, I'm loaded for bear.
Oh, right. The floor will be yours. Dr. Sheargold, any thoughts from your perspective?
I think what's interesting with regards to subsequent agreements and interpretive notes, which we're seeing states use more, is I think the flexibility of the VCLT rules, which simply say those have to be taken account of, but don't say how much weight should be given to them, is what's actually leading to states in some respects sort of displacing or adding on to those rules in their newer treaties by stating that these will be binding interpretations and tribunals have to follow them. I think it's an example of an area where states are seeing that the VCLT rules haven't necessarily delivered the certainty that they want. And so we're actually seeing a bit more adaptation and specialization in the investment treaties themselves.
Kiran.
Thank you, Meg. I might start us off with 3 propositions. The first is the VCLT, as you've heard from both Julien and Judge Brower, is highly rules-based. So it's a very systematic, flexible, but certainly very systematic approach for how to interpret treaties. Second, in ISDS in particular, especially given the last decade of practice, we now have a vast number of decisions and procedural orders and interpretive approaches in advocacy and decision-making upon which we can be drawing from. And I think that makes this field of practice quite unique going forward, because we have data that can be harnessed. And in this present environment where parties and institutions and decision makers are all looking at data analytics and various tools that can support them in doing things correctly, again, I'll say coherently, consistently, predictively, in a positive way, the VCLT is a really great guiding note for that. And then the third point I might make is just about transparency. So we have this sustained body of practice that's publicly available that we can, write a book like this that we can interpret and draw conclusions from because we have access to that information. But going forward, as the various regimes that we're engaging with, where treaties provide for greater transparency, where institutional rules provide for greater transparency and public participation, amicus submissions. We, of course, have the non-disputing party submissions, but we have amicus parties as well sometimes, increasingly so, including public fora for watching hearings, which ICSID now provides for from time to time. When you put that all together, the VCLT and its use in this particular field of public international law becomes increasingly more interesting, especially in light of looking at how various fields of public international law are starting to dovetail. I think the next generation of disputes that we'll see will not be only about international economic law, but they will dovetail with climate law, with environmental law, with human rights law, and so on and so forth. So when you have all these fields intersecting and intermingling and drawing from each other, I think the ISDS practice in particular not only will be richer for it, but will have a lot to offer to other areas of law that are newly emerging.
But maybe even a greater need for sort of treaties that will guide you in your interpretation, like a Vienna Convention. Yeah, exactly. Interesting. And Esmé, anything as a last word to add?
I guess kind of to pick up where I started, the book really aims to show how the VCLT has played a really key role in investor-state disputes to date. But another aim in developing the book is really to think about what role the VCLT might play into the future. And I think it's fair to say that the chapters sort of highlight the full range of techniques within the VCLT as kind of almost a toolbox that states and litigating parties, NGOs, tribunals might use to shape what investment treaties and investor-state arbitration look like into the future. I think the other kind of point to pick up on that's run through the discussion is the flexibility and openness of the VCLT to other approaches. And so many of the provisions in the VCLT clarify that they'll apply unless the treaty parties supply a different approach to the given issue that's being regulated by the VCLT. And we see states in their treaties adopting different or more specific approaches to some of these key issues of treaty law. As we've heard from Liz, that can include directions around interpretive notes and subsequent agreements. As we've heard from Julien, it can also include specific directions around territorial application. I mentioned earlier specific directions around the provisional application of treaties. I think the interesting thing for all of those more specific or different approaches in treaties is that usually the VCLT and how it's been applied to date is serving as the baseline and the inspiration for states to be adopting these different approaches to key issues of treaty law. So understanding how the VCLT has been applied to date is really useful for drafting and calibrating these clauses to ensure they're capable of meeting the state's policy goals in drafting them. So really it's kind of, hopefully we've highlighted in this discussion, but also in the book, that the VCLT provides a kind of disciplining logic. It sets up rules and frameworks that can assist states and other stakeholders in the investment treaty regime to navigate quite complex issues of treaty law in a predictable and structured way. But at the same time, it's flexible enough to accommodate change, including to incorporate new voices and different approaches to some of these issues. So thanks again for hosting the discussion, which I think has been really interesting and hopefully highlighted for everyone present the book's approach and the range of additional chapters that can shed light on some of these cross-cutting things.
And second editions, too. I think there are a few questions that came up today that will fuel that. If I can now, I'd like to open the floor to audience for questions or comments. You have 5 incredible experts here to ask anything you ever wondered about. So please take that opportunity. All right.
Yeah. Then you ask for the second question.
I'm still on the first. Very good. All right. Well, then, what's left to me, and on behalf of all of my colleagues at ICSID, is to thank you so much for coming here today, to thank in particular our speakers, and in particular our Australian speakers. I don't know what time, I didn't ask you what time it was there, but very much appreciate you joining us as well. And I'd like to invite everyone here to end their Friday on a very positive note. We have some refreshments, and hopefully we can continue some conversations over here in our back room. Thank you very much, and join me in some applause for our speakers.